When is divorce mediation not recommended? Divorce mediation is a commonly sought-after method for resolving marital disputes amicably. In fact, mediation has increasingly become popular over the years for providing couples going through a divorce with a less antagonistic means of deciding on their affairs. However, studies have shown that, despite divorce mediation being the popular alternative for couples wanting to avoid litigation, there can be crucial factors that affect how effective it is as an alternative dispute resolution method. What is divorce mediation? Divorce mediation is a voluntary process where divorcing spouses work with a neutral third party, known as a mediator, to facilitate discussions and negotiations aimed at reaching mutually agreeable resolutions. This process fosters open communication and allows couples to have more control over the outcome of their divorce. The benefits of divorce mediation. Connecticut recognizes the advantages of divorce mediation, which include cost efficiency, faster resolution, confidentiality, customized solutions. Advantages of legal representation. Connecticut law recognizes several advantages of having legal representation during divorce. Legal guidance. Protection of rights. Complex cases. Disadvantages of mediation. It is important to remember that, as an impartial third party, mediators cannot act as lawyers or provide legal advice. In cases where there is a power imbalance between the spouses, the mediator may not advocate for the disadvantaged spouse. In extreme cases, without judicial intervention or the advocacy of a dedicated attorney, the spouse with less power may agree to a less favorable settlement than they are entitled to. On the other hand, legal representation can ensure that the rights of a disadvantaged spouse are protected and that their best interests are prioritized. What happens during divorce litigation versus divorce mediation? Divorce litigation and divorce mediation are two distinct processes for resolving issues related to divorce. Here's an overview of what happens during each process. Divorce litigation. Filing the complaint. Response and counterclaims. Court appearances. Trial. Final judgment. Appeals. Divorce mediation. Voluntary process. Mediation sessions. Open communication. Drafting agreements. Voluntary agreements. Court involvement. Key differences. Control. Cost and time. Adversarial versus cooperative. Confidentiality. When is divorce mediation not recommended? While divorce mediation is a viable option for many couples in Connecticut, there are specific situations where it may not be the most suitable approach. It's important to consider these factors before deciding on mediation. When the dynamics of the relationship are highly charged and emotional. Connecticut law recognizes that the process of divorce can be emotionally charged. When there are issues of significant substance abuse. Connecticut law acknowledges that substance abuse issues can significantly impact divorce proceedings. When domestic violence is a factor. Connecticut takes allegations of domestic violence seriously in divorce cases. When one party is coercive or controlling. Connecticut places a strong emphasis on fair and equitable divorce proceedings. When a party feels intimidated by the other spouse. Connecticut laws are designed to ensure that both spouses have an equal voice in divorce matters. When there are disputes regarding child custody, best interests of the child. Connecticut prioritizes the best interests of the child in divorce cases involving child custody disputes. When there are complex financial matters. Connecticut's legal system acknowledges that divorce cases involving complex financial issues, such as significant assets, business interests, or intricate financial arrangements, may not be suitable for mediation alone. When one party has an advantage or more knowledge about marital assets than the other spouse. Connecticut law ensures that both spouses have access to all relevant information and can make informed decisions during divorce. Alternative dispute resolution options. As mentioned, undergoing divorce mediation is the popular choice among couples who want to try a less combative approach in deciding the matters of their divorce. But what happens when mediation doesn't work? Here are some alternatives that you and your attorney can explore to ensure that your rights are protected. Collaborative divorce. Collaborative divorce is a process in which divorcing spouses work together, each represented by their own attorney, to resolve issues related to their divorce outside of the courtroom. Traditional litigation. Traditional litigation involves going to court to resolve divorce matters. It may be necessary when other methods fail, but it tends to be more adversarial and costly. Attorneys versus mediators. Understanding the roles and benefits of both divorce attorneys and divorce mediators is essential for making an informed choice in choosing which approach you would like to take. In both cases, each party can hire an attorney to represent their interests. However, the process is different in that rather than presenting arguments in their favor, as in traditional litigation, each party enters a conversation in the interest of negotiating the terms of their divorce agreement. In Connecticut, attorneys contribute the following services to their clients. Advocacy. Legal experience. Negotiation. Mediators in Connecticut act as neutral third parties to facilitate communication and negotiation between divorcing spouses. Neutrality. Conflict resolution. Agreement drafting. Contact McConnell Family Law Group today at 203-344-7007 to schedule a consultation.